Good evening, everyone, and welcome to the 29th Mayflower Lecture. It is a distinct honour to stand before such a distinguished gathering of students and professionals. Today, we are privileged to host a leader whose career and character have become an embodiment of justice, integrity, and trailblazing excellence. Please allow me to introduce the first ever Lady Chief Justice, Dame Sue Carr, a name synonymous with legal expertise, unwavering fairness, and a profound commitment to the rule of law. As the head of our judiciary, she has not only upheld the highest standards of legal interpretation and decision-making, but has also championed transformative reforms, ensuring that justice becomes more accessible, equitable, and inclusive. Her journey is a testament to perseverance, intellect, and purpose. Rising swiftly through the ranks in a profession historically dominated by men, she has shattered barriers and redefined leadership in the legal field, inspiring countless young lawyers, especially women, to dream boldly and pursue their aspirations. Many of you here will have heard me speak before about the need to push back against outdated perceptions and biases and to advocate for an environment where women can succeed at every level of their careers. The future of law depends on the diversity of its practitioners, and the inclusion of women at every level strengthens the profession. It's taken close to 800 years for us to see the first Lady Chief Justice, and I'm delighted to celebrate that in a year that sees, for the first time in Plymouth Law Society's 209-year history, a female immediate past president, a female president, and a female vice president. This is also the year that sees, again for the first time, a female president of Plymouth Law Society, a female chair of Plymouth Junior Lawyers Division, and a female president of the University of Plymouth Law Society. And I hope that you'll agree with me that these are firsts that really should be celebrated. For the students here today, Dame Sue Carr's story demonstrates that success in law requires not only knowledge, but also courage, empathy, and a commitment to lifelong learning. For the seasoned professionals amongst us, she reminds us of the profound responsibility we hold in shaping a society where justice prevails. And I think I can safely speak for us all when I say we eagerly look forward to her insights, wisdom, and guidance as she shares her perspectives on the evolving legal landscape and the critical role that each of us plays within it. Friends, colleagues, and distinguished guests, please join me in extending a very warm welcome to the Lady Chief Justice, Dame Sue Carr.
Thank you for such an inspiring welcome. I feel like tearing my speech up and just taking it from the top. I am truly honoured and delighted to be with you all this evening to give this year's Mayflower Lecture under the title Enacting Just and Equal Laws, Enforcement and Fair Trial, joining a long list of previous distinguished speakers, and to be here on such a special day, the 28th of November, for we celebrate today the anniversary of Lady Astor becoming the first female MP for Plymouth Sutton back in 1919. To mark her motivation for achieving that particular post, she said this: "I wanted the world to get better, and I knew it couldn't possibly get better if only men ruled the situation. In fact," she said, "it's amazing how well they've done really for the last 2,000 years. Anyway, true to the origins of this lecture, I have taken as my subject human rights, although perhaps an aspect that may tend to be overlooked. My starting point, though, is, as it should be, the Mayflower, and specifically the Mayflower Compact. Having set sail from Plymouth on the 16th of September 1620, the Mayflower sighted land on the 19th of November. Specifically, they caught a first glimpse of what is now Cape Cod. They saw what, for Scott Fitzgerald centuries later, would symbolize the American dream, one, of course, he emphasized, could never be attained. That it cannot be attained, yet is always nevertheless to be strived for, is, of course, its essential quality. Rather than dwell on such matters, the passengers on the Mayflower took a far more practical approach. They realized that if they were to survive, they needed to devise a legal framework for their new community. That framework, arguably America's first attempt at a written constitution, was the Compact. It was a short document, of which the original does not in fact survive. But within it, the signatories agreed to covenant and combine themselves into a civil body politic for their better ordering and preservation and furtherance of the ends aforesaid, and by virtue hereof to enact, constitute, and frame such just and equal laws, ordinances, acts, constitutions, and offices from time to time, as shall be thought most meet and convenient for the general good of the colony. On the 21st of November 1620, the compact was signed, and the agreement to create a society that would enact just and equal laws took effect. It's one thing to enact such laws, it's another to live according to them, and that is where fair trial and enforcement come in. Fair trials are, of course, essential if rights, just and equal laws, are to be vindicated where they have been infringed or otherwise breached. As Lord Reed put it in the Unison case, without access to courts and hence to fair trials, laws are liable to become a dead letter. The right to fair trial has many elements to it, both as it has developed at common law and under Article 6 of the European Convention on Human Rights. Both emphasise, for example, the need for an independent and impartial judiciary, for practical and effective access to justice, for equality of arms between litigants, for practical and effective access and equality of arms across the board. But there is one aspect of the right to fair trial that can perhaps be too often overlooked. That is the right to effective and timely enforcement. It's one thing to provide effective access to the courts and judgment, but without a mechanism to ensure that judgments are implemented, the right of access to a fair trial would be illusory, wouldn't it, rather than effective? And in this year's lecture, I want to explore this aspect of the right to fair trial. My starting point is what was called by Professor Moreira, as long ago now as 1985, the greatest possible coincidence principle, something which sounds more like something you probably would think Sherlock Holmes would be talking about. But specifically, it explains the ultimate purpose of enforcement. Before I get there, let me take one step back. There is an idea that the civil and family courts exist to resolve public and private law disputes. It's sometimes referred to, including the tribunals, of course, as the dispute resolution story. On one level, that is undoubtedly correct. Individuals bring their disputes to the courts for them to be resolved. The courts make findings of fact and apply the law to those facts. The end product, a judgment, the means by which rights are vindicated, and in that way, the dispute is resolved. But on another level, that story is at best a partial one. Our civil courts, our family courts and tribunals play a far more significant role than mere dispute resolution, although the wider role depends on access to courts and the judgments they hand down, because through their judgments, we help to provide the socio-legal framework within which individuals and businesses can order their affairs between themselves. So they help to prevent disputes arising, because they provide the basis on which members of civil society can gain an understanding of the law and its application, what their rights and obligations are, what the consequences of breach are likely to be, and conversely, what the benefits of acting within the law are also likely to be. Now, that can be done with or without legal advice, though I'm sure that the lawyers in this evening's audience would no doubt stress that such an understanding comes best with the benefit of legal advice. But one of the courts and tribunals' wider roles can best be summed up as promoting prevention rather than cure. They have other roles, but that's another story for another day. This preventative role is a generally acknowledged but crucially important one in society. It's well known that our substantive laws are not self-executing. a point emphasised by Jeremy Bentham in one of those moments when he was stressing the necessity of courts and procedures that enable them to give effect to the law. For most people, and for most of the time, the fact that laws are not self-executing is not a problem, for one of the hallmarks of civil society is that for the most part people do abide by the law. They give effect to their obligations. They respect each other's rights. What we see as judges is in fact, truly, sometimes the exception. Where disputes do arise and individuals and businesses need to resort to the courts to resolve them, it is important that they can do so in a timely and cost-effective manner. And here, ladies and gentlemen, is the first aspect of the greatest possible coincidence principle. Where law is self-effecting, its benefits come at a cost. That cost is determined by the nature and the complexity of the law itself, and the steps that need to be taken to ensure that those to whom it applies can act in accordance with it effectively. Laws that are well structured, clear in their scope and application, try to minimise those costs, but such costs there will be. And where disputes arise and litigation is commenced, additional costs arise: court fees, lawyers' fees, fees associated with evidence gathering, expert witnesses, navigating the courts, their practices and procedures. It's well known, and no doubt it was at the time of the Mayflower, that we constantly seek to reform our courts and their processes to ensure that individuals can litigate efficiently and cost-effectively. Since the 1980s, we've particularly focused through reform programs stemming from the Civil Justice Review, via the Wolfe and the Jackson reforms, to the Briggs reforms, and most recently, the modernisation programme. The key point, though, is that our approach to litigation costs should be that we strive to minimise them, so that the cost of dispute resolution, of securing a judgment that gives effect to the law, is as close as possible to the cost of self-execution. The two can and never will be fully coincident, but that shouldn't stop us from striving to reform our courts and tribunals so that they keep the two costs as close together as realistically possible. And this takes us to Professor Moreira's point. It is one thing to secure a judgment, but that may not always be the end of the story. A judgment may require a defendant, for example, to pay a debt, to pay the claimant damages, to cease acting in an unlawful way. It may require a company to stop manufacturing a product in breach of a patent, or it may require a ship to be detained as security. In all such circumstances, the judgment itself is insufficient. Something more is needed. And this is where the enforcement process comes in. Enforcement proceedings need to be taken, but they too come at a cost. And the objective of this process, if I can borrow from the professor, the objective of the enforcement process should consist of the attainment of a practical result coinciding exactly with the one that would be attained through voluntary compliance with the judgment or order. And if exact coincidence is not possible, the objective should be to produce a result as near to the ideal of coincidence as possible. And so again, we can see both the ideal and the realistic alternative. In both instances, our aim should be to try to minimize the costs that arise over and above the costs of self-execution of the substantive law. This is the greatest possible coincidence principle. Two issues arise from this. First, how might our enforcement processes seek to achieve this objective? And secondly, to what extent does our approach to enforcement strive to attain this objective? If we compare, for instance, the amount of time spent on reforming our enforcement processes since the 1980s with the time spent on reforming our civil courts processes, we might wonder, might we not, why so little has been spent on the former and so much on the latter. Systems change. The first issue we might look at is one centred on how we organise our approach to enforcement, a systems approach. Different countries have taken different approaches to this. Wendy Kennett, the leading English authority on enforcement, identifies 3 broad models that have been adopted. The first she describes as the administrative model, common to Sweden and Finland. It requires the state to establish an executive agency, which is then responsible for the enforcement process. The second model, which you can find in France, Belgium, the Netherlands, and some other European countries, she calls the judicial officer model. This places the enforcement process in the hands of a branch of the legal profession separate from lawyers. It's a model which evolved from 14th century France and sees enforcement carried out by what are known as huissiers de justice. The third, the final model, is court-centred. It sees courts responsible for enforcement of judgments, following applications to that effect by creditors. Court-centred models might place the entire enforcement process in the hands of the court and court officers. They might also take a hybrid approach. As you might expect, we here take the latter. Enforcement is overseen by the court under provisions contained in our civil procedure rules and carried out by what are commonly known as bailiffs. And where enforcement is carried out through the county court, they are either authorised by the court or employed by the court itself. Where it's carried out in the High Court, it's carried out by what are now called High Court enforcement agents, individuals authorised by the Lord Chancellor. Each of the models, I think, has much to commend it, but also potential drawbacks. The administrative model, by placing responsibility for enforcement in the hands of state bodies outside the justice system, ensures that the courts are not encumbered with the time and cost of enforcement, thus minimising the costs of achieving enforcement of a judgment. The judicial officer model can also promote cost efficiency and effectiveness, not least through promoting effective competition between its huissiers. And the court-centred model could seek to achieve the same benefits as both of the other 2 models by promoting public service, competition, and regulating authorisation as an enforcement agent. By engaging the court, though, that is a call on time and resources, which can adversely affect court performance elsewhere. If we were considering how best to minimise the cost and time of enforcement, we could spend some time looking, I think, with fresh eyes at the nature of the model that has evolved here. As with many of our institutions, it can be traced back to pre-Norman England. The term bailiff we owe to the Normans, its Saxon precursor, the shire reeve, or sheriff as it became, was also adopted by the Normans and lived on until recently. The civil courts know about all of these problems, again, as the Mayflower passengers would have seen. If the passengers had wanted to pursue legal claims before setting sail, they would have been faced with a welter of different superior courts, with variously overlapping, competing, as well as complementary, albeit unique, jurisdictions and procedures, all of which had evolved over time to meet the exigencies and spirit of each passing age. That system, as perfect as it seemed to some, and some people like Blackstone really did think it was perfect, was nevertheless entirely unconducive to securing judgments on the merits of disputes at minimal cost and in a reasonable time. On the contrary, it excelled in maximising the cost and time taken to resolve disputes, and in far too many cases did so without resolving them on their merits. So where access to justice was concerned, it was a system that was more than wanting. Unsurprisingly, it did not survive the Victorian era. Rationalisation came through the Judicature Acts and the many superior courts becoming one. If a reformer were to take a systems approach, a starting point might well be to consider what type of system was best suited to secure effective enforcement today. This is something that has not often been considered, and where it has not been considered, I think, from first principles. In 1969, the Committee on Enforcement of Judgment Debts looked at this type of question, but only to a limited extent. It recommended that enforcement of civil debts carried out in the magistrates' courts, that system could be transferred to the county courts. A degree of rationalisation based on the idea that the best way for civil matters to be dealt with was for them to be dealt with in the civil courts and not what was primarily a criminal court. Step forward in time to 2007, and some significant reform was introduced by Part 3 of the Tribunal Courts and Enforcement Act. The law concerning how a creditor could secure effective enforcement through taking control of a debtor's goods was, for instance, updated, as was the regulation of enforcement agents. Other reforms in the legislation were not, however, brought into force. Again, a degree of rationalisation and updating. Perhaps most telling in this respect is that we have now passed the 25th anniversary of the civil procedure rules, following the Wolf reforms in the 1990s. The rules were intended to be a new procedural code, and their overriding objective referred to them as such, but the word new was excised from the rules in 2022. But yet that no longer new code still does not make complete provision for all aspects of enforcement. More recently, Lord Briggs considered whether and to what extent enforcement in the civil courts ought to be reformed. In 2016, the Civil Court Structure Review considered the approach that ought best to be taken in the civil courts. It proceeded on the basis that enforcement was inherently a court process. The administrative and judicial models might have suggested that while that might be the case in England and Wales, it need not be the case. But in the light of that, the review went on to conclude that civil enforcement should become the sole province of the county court, albeit with the ability to transfer enforcement to the High Court where necessary. Whilst some reforms were brought into force, therefore, following the review, rationalisation, as recommended, did not. Most recently, the Civil Justice Council has established a review of enforcement. Its work is at an early stage, and a call for evidence has just closed. Two of the questions raised, and perhaps the most important, as they go to the heart of the issue of effective enforcement, were this. Do you consider that there should be any changes to the system of enforcing judgments, or should the status quo be maintained? If you consider there should be changes, what changes do you feel should be made to make enforcement more accessible, fair, and efficient? These questions go well beyond the Briggs Review. They invite an examination of whether the enforcement system as a whole stands in need of reform. They invite consideration of whether enforcement should remain an inherently court-based process, or whether there is merit in adopting an administrative or a judicial model, and if so, on what basis. They also invite consideration of what reforms might be necessary if a court-based model is retained. Should we create an enforcement court, perhaps? Unify all enforcement in the county courts, or in an online court? Is there a need to reform the structure and governance of who carries out the enforcement process, and if so, how, and in what ways? These questions raise the question of principled and principle-based reform. That was the approach taken in 1873 to the civil courts. The principles that guided the approach then was that the courts had to operate so as to secure justice whilst minimising cost and delay. As the professor would put it, to give effect to the greatest possible coincidence principle. I think the same approach could be taken to enforcement, and I very much hope that the Civil Justice Council's review looks at the issues in depth and with a view to making recommendations that seek to give effect to that principle to the greatest degree possible. In doing so, they may well consider work currently being completed internationally by UNIDROIT, the International Institute for the Unification of Private Law. It is currently finalising a long-term project articulating best practices for effective enforcement. And no doubt it too is looking at how best to give effect to Moreira's principle. Where it can be implemented fully, both creditors and debtors benefit, and in that way, I think, so does society as a whole. Moving away from systems now, narrowing down from a systems focus, I want to turn to the individual case, and here I want to look at individual practices that have been adopted to minimise the cost and time involved in effective enforcement. My starting point here is something that might appear to be an instinctively attractive option. It might be thought that the best way to secure effective enforcement would be to take steps as early as possible in the litigation process. Why wait until judgment to enforce? Why not simply provide the means for a claimant to commence enforcement before they have obtained a judgment in their favour? In other words, why not let a claimant obtain security for judgment? But it is, I'm sure you all know, very well established that our courts do not have the power to grant security for judgment. This was the considered issue in the 1890s in Lister and Stubbs. Lister were manufacturers, silk spinners and dyers. Stubbs was employed as their foreman dyer. He had for a long time been entrusted by a company to buy products that they used in the dyeing process. Stubbs took this as an opportunity, no doubt welcome for him, to supplement his wages. Without his employer's knowledge, he made a significant personal profit from orders that he made on their behalf. As the judgment put it, he secured for himself large sums by way of commission. And of course, when his employer found out, they were none too happy. Proceedings followed. During the course of the litigation, Lister, the employer, applied for an interlocutory injunction, seeking to restrain Stubbs from dealing with the real estate in which he had invested his ill-gotten gains. It also sought to require him to bring his other investments and any remaining money into court. The basis for this was that Stubbs held all this property and money as trustee for Lister, but the Court of Appeal rejected that argument. It held the relationship between the two was not trustee and beneficiary, but creditor and debtor. It would be wrong, it said, to order the defendant to bring the money into court or for the court to restrain use of the real estate. As a general principle, a claimant simply has to run the risk that a defendant may, when judgment comes, no longer have assets sufficient to satisfy the judgment. It was not for the courts, they said, to interfere with a defendant's substantive rights, particularly property rights, simply because a claimant was pursuing proceedings against them. That was until Lord Denning arrived in 1975 in Nippon and Karagordis. This was a case concerning 3 ships, very topical, chartered by Japanese ship owners to Greek charterers. At some point, the charterers failed to pay the hire charges on 2 of the ships that were due. The ship owners believed the charterers had funds held in a bank in London, and they feared that they would be transferred out of the jurisdiction. And then, of course, it would be difficult for them to secure funds to satisfy any debt found to be due to them. Now, we know that the courts would not grant the ship owners security for judgment, but nevertheless, the ship owners applied for an interim injunction, one restraining the charterers from removing their assets outside the jurisdiction. The application was refused by Mr. Justice Donaldson. The ship owners appealed, and the appeal was allowed, and Lord Denning, noting that such an injunction had never before been granted by the courts, put it thus: "It has never been the practice of the English courts to seize assets of a defendant in advance of a judgment, or to restrain the disposal of them." But he went on to conclude that the time had come for the law to change. As he explained, "It seems to me," and I can't do his wonderful accent, "that the time has come when we should revise our practice. There is no reason why the High Court or this court should not make an order such as is asked for here. It is warranted by Section 45 of the Supreme Court of Judicature Consolidation Act 1925, which says that the High Court may grant a mandamus or injunction or appoint a receiver by an interlocutory order in all cases in which it appears to the court to be just or convenient to do it. It seems to me, he said, that this is just such a case. It was just and convenient to do so because there was a strong prima facie case that the money was due and owing, and that the defendant's assets would likely be removed from the jurisdiction in the absence of an injunction, and where enforcement was concerned, that would leave the claimants with the greatest difficulty in recovering anything. It would, in other words, going back to my theme, increase the time taken to secure judgment, enforcement, and its cost. It would frustrate, I would say, the court's ability to give effect to the greatest coincidence principle. A short time after that judgment was handed down, the Court of Appeal returned to the question of whether such a form of injunction was permissible in the very well-known case of Mayflower and bulk carriers. There, the court considered whether its previous decision in Lister meant that it had no jurisdiction to restrain a defendant in this way. In the Nippon case, the court had not been referred to the Lister decision. Again, in Mayflower, Mr. Justice Donaldson had refused to grant the interim injunction, relying on Lister. Again, the ship owners appealed. Again, the Court of Appeal allowed the appeal, relying on Section 45. And Lord Denning, for it was he again, explained the provision, providing that the court could grant an interim injunction whenever it was just or convenient to do so, had been given a wide interpretation. It was an unlimited power. He went on to conclude, that principle applies to a creditor who has a right to be paid the debt owing to him, even before he has established his right by getting judgment for it. If it appears that the debt is due and owing, and there is a danger that the debtor may dispose of his assets so as to defeat it before judgment, the court has jurisdiction in a proper case to grant an interlocutory judgment so as to prevent him disposing of those assets. And with that affirmation, the Mayflower injunction was born. Now it is, of course, known as the freezing injunction, not least because it has a chilling effect on the potential for defendants to attempt to frustrate the enforcement process before either a judgment is given or after it's been given, but the enforcement process has not been completed. Since those decisions, as I'm sure you know, the freezing injunction has developed. Orders for disclosure can now be made to support its efficacy. It can apply both within the jurisdiction and worldwide. It can be supported by civil search orders. These developments, I think, make clear how our courts and their processes have evolved so as to help secure the effective administration of justice. When they had no power to order default judgment, they developed a means to ensure that defendants could not frustrate justice by not engaging with the court. Where they could order default judgment, that coercive power fell away. When it became easy for defendants to frustrate effective enforcement by moving their assets outside the jurisdiction quickly through, for example, electronic forms of transfer, the freezing injunction was developed. Each of these processes demonstrates how the courts seek to minimize the cost and the time taken to secure effective judgment and enforcement, and particularly with freezing injunctions, how they seek to minimize enforcement cost and time. Whether knowingly or not, they are developments that seek to give effect to Professor Moreira's principle. To conclude with a look at the future, where might all this take us? The freezing injunction played a key part in supporting the development of commerce in the City of London in the 1970s, when commercial parties could move their assets more easily than might have been possible in the past outside the jurisdiction. For the English and Welsh courts to remain ones that could deliver effective access to justice and enforcement, for those engaged in domestic disputes, and for those engaged in international disputes litigated in London, there was and remains a need to provide the means to secure justice. And that entails the need to ensure that justice's achievement is not capable of being frustrated by the parties, or, more generally, by the cost and time taken to secure effective judgment and enforcement. One of my predecessors, Lord Thomas, once commented on the relationship between the commercial court and arbitral proceedings. He made the point that it was one of maximum support, minimum interference. That is, that the court should support effective arbitration as much as it could, whilst leaving arbitral tribunals to resolve disputes before them as much as it possibly could. A similar point can be made about litigation itself. Our civil courts ought to be capable of providing maximum support to parties to proceedings, enabling them to achieve justice and its enforcement effectively, economically, and in good time. This may mean that we need to develop new procedures to meet the needs of the day, something, for example, we do through user groups. Each of these, and we keep them, each other, in touch with developments concerning the subject matter of disputes being brought before the courts, and it enables us to keep in touch with the concerns of court users about, for example, where reform and improvement are necessary. Maximum support may also mean developing new procedures to deal effectively with significant developments that flow from the ever-increasing digitisation of commerce. That may mean, as we have done, that the courts need to develop their approach to digital assets, NFTs, cryptocurrencies, and so on. Where once it may have been relatively straightforward for the courts to issue orders that resulted in a ship being made subject to arrest, ensuring that it was not taken out of the jurisdiction, or to issue an order freezing a bank account, it must also be just as straightforward for them to be able to effect similar orders in the digital sphere. And the courts are, of course, doing so. We have issued freezing injunctions concerning cryptocurrencies such as Bitcoin and Ethereum. Further developments will no doubt be needed as time goes on and as the digitization of markets and society continues. In this regard, both the Civil Justice Council's review and UNIDROIT's Best Practices project, focusing particularly on how to secure effective enforcement in a digital world, will be, I think, of acute importance. We will need to give very careful consideration how to secure an enforcement system that is as effective as it can be, as well as we can best secure enforcement in individual cases, so system and cases. In all cases, we should, however, seek to ensure that we keep the cost and we keep the time of enforcement down to a minimum. That ought properly to be our guiding principle where reform is concerned. If it is, like the Mayflower passengers and their attempt to create a practical legal framework through the Compact, we will be able to maintain our commitment to the implementation of a justice system able to secure practical and effective enforcement. And through that, we will continue to give effect to just and equal law. Thank you very much.
Thank you very much, Lady Chief Justice. That was wonderful. I'm Phil Bates. I'm the Associate Head of the School of Society and Culture here at the university, and I'm the Head of Law for the time being. And it's absolutely wonderful to come to a lecture and to be given a new way of thinking about things that were familiar, but to suddenly think about them in a different way than normal. And I think it's absolutely right that so often we're thinking in terms of the legal outcome and not then thinking about the enforcement of that. And just in terms of my own teaching, I was thinking about that, how that relates to things that I do. And just today, earlier this evening, I was lecturing on family law. We were talking about child contact. We were talking about how it's one thing for the judge to decide that it's in the interests of a child to have contact with a parent, but then how can that order be enforced where there's an ongoing issue of opposition from the other parent, sometimes the child themselves, and how, on the one hand, the law may be promising justice or promising what is best for the child, but then that promise would be undermined if we don't see it through as far as enforcement. And the inequality, the unfairness, the disrepute into which the system will fall if we don't follow through on that promise. So it really struck a chord with me in that way. It also reminded me earlier in the course where we talk about the enforcement of child maintenance obligations. And when I was much younger, actually my undergraduate dissertation, I was looking at the implementation of the Child Support Act and how the issue of child maintenance that used to be dealt with through the courts with all of the advantages, but also many of the disadvantages of a court-based system of enforcement, and how, because of some of those disadvantages, the shift to an administrative, as it then was, the Child Support Agency, which had advantages, but also many disadvantages, and how the issue of enforcement was a much more significant part of that picture than the idea that a parent should be financially responsible for their child. So the principle of law, the principle that we want to achieve, very much worthwhile, but then if the law doesn't have the systematic, effective, affordable ways to achieve those results, then it undermines the whole picture. So those were issues that had been at the back of my mind that I touch on in various ways throughout my teaching, and I'm sure for other areas of law that the students are studying. Issues of enforcement will come up in places, but often as a sort of afterthought, as and by the way, it might be really difficult to enforce that, and if you haven't got loads of money, you may as well forget it. And actually, as we've heard, as it's been demonstrated so wonderfully, it should be at the heart of our thinking about making the system work for everybody fairly and equally. And I'm enormously grateful for opening my mind to something that was unformed in the back of my mind. I hope for everybody else there was a similar, whatever your area of law, whatever your area of interest, I hope there was that sort of connection to, oh yes, actually, that's a really important part of the things that I do, or even if it's not something I do every day, it connects with an area of interest. So thank you so much for a wonderful lecture. Thank you for coming to see us. We're always enormously grateful. The students benefit enormously from getting the chance to meet people who come to do the Mayflower lectures, and we've been so lucky to have such a wonderful series of lectures. We're really grateful to Plymouth Law Society for their support in organising this and hosting these events for us, the university itself, the Plymouth City Council for all the support they give. One of the things I said earlier this evening in a small group, I love the fact that Plymouth has these connections between the university, the city, the legal profession, the community. It compared with every other university I've worked in the country, it feels like a community. We are so happy to welcome new people to come visit us, to tell us. But the fact that Plymouth is able to host people and to bring people together for an event like this is wonderful. So thank you all for being here. Thank you to the speaker. It's another really fantastic event, and I'm so grateful. Thank you.